All right, we have before us the first case of Malcolm King versus Kelsey King. We'll take a short break after the first case and proceed to the second one. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
May it please the court. My name is Christine Davis. I'm here on behalf of the appellant, Chad King. I'd like to reserve 3 minutes for rebuttal.
You may. Thank you.
We've raised three primary issues in this appeal, and I'll address them in the order they appear in our brief. The first issue is that the trial court erred in not considering all of KIA's assets and liabilities in reaching its determination of fair market value of the company. The trial court accepted the husband's expert's valuation using the market approach for the valuation of the company. That valuation included all of the assets and liabilities of the company except for non-operating liabilities, which were to be deducted at the end, and his testimony made that clear. Those non-operating liabilities included the Westfield Bank loans and the shareholder loans. So it ends up being about $724,000. And Trugman made clear, the expert made clear, that non-operating liabilities had to be deducted from the value of the business to reach a true fair market value. As the cases we cited in our brief make clear, courts are to consider all assets and liabilities. The value of a company is the sum of all of its parts, not just parts that you can pick and choose. In the answer brief, the wife asserted that the non-operating liabilities can be ignored because the trial court supposedly ignored certain assets of the company and value in the company. And that's, as we explained in our reply brief, that's not actually what happened. Trugman did his market approach by comparing comparable asset sales of similarly situated insurance agencies. And those asset sales showed what a company would sell for the assets that are sold with the company, those that are typically sold in the company. Once you reach that value, you go to the net retained assets that he considered. And those are the assets and liabilities that the seller of the business would ordinarily keep, such as cash on hand and any other liabilities that aren't typically sold. Trugman considered that as well. So Trugman considered the very items that the wife said in the brief were ignored. Then you can't stop the analysis there, though, and Trugman made that clear. You have to consider the remainder of the liabilities, and those were the non-operating assets and liabilities. Here, there were only non-operating liabilities, which were the shareholder loans and the Westfield Bank loans. So by failing to include those loans and those liabilities in the fair market valuation, you come up with a grossly inflated value of the company. And that's exactly what Florida law prohibits.
And counsel, the appellee suggests that almost a tipsy coachman argument that there was evidence in the record that there was a $3.8 million offer on the company that was made, which would support a valuation higher than the experts. Can you explain why or why not would that not be appropriate?
Well, to begin with, the trial judge in the case said she'd heard enough about this one offer because there had been no real evidence introduced as to what it was. You had some people testifying about it, but then you had this one offer that was created. The judge said she didn't have enough evidence and she didn't want to hear about it. The offer was created for purposes of this litigation, so it's completely unreliable. And while you have one person who created a offer that was created for this litigation, it just can't, when you're looking at two experts' opinions, the judge adopted Trugman's valuation, and that hasn't been challenged on this appeal. So while there was other evidence considered, the trial judge adopted Trugman's, but she just adopted half of it and didn't adopt whole of it. So McKibben's offer shouldn't be considered in that because, for one, there was no evidence, real evidence showing the full parameters of that offer, and it's completely unreliable, created for the purpose of litigation.
And just one hypothetical, even if there were competent, substantial evidence of that offer in the record, would we be able to affirm on tipsy coachman grounds just because that valuation was in the record?
No, I don't think so. I think that the trial court adopted Trugman's analysis, just half of it, and nobody has challenged that. They didn't file a cross appeal saying you should have considered McKibben's offer as fair market value instead of Trugman's valuation. So I don't think the court could accept that as evidence, even if it were competent evidence, which it's not.
Thank you.
The trial court also erred in calculating the amount of personal goodwill that the husband has in his insurance agency for several reasons. First, the court applied the wrong legal standard. The court said that the husband had a mere 7.3% personal goodwill in this company, and it was based on the fact that she believed it would be unreasonable and inequitable to award the wife a lesser amount of the business because marital funds were used to purchase the company. The wife served as a bookkeeper and performed some other administrative duties for the company, and she took care of the children. That's completely irrelevant to a personal goodwill valuation. Personal goodwill looks only to the value that the husband brings to the business personally based on his relationships with clients and reputation in the community and things like that. And the evidence were that he had strong relationships with his clients and he was a consistent force in this business. So what the trial court believes would be reasonable to the wife is completely irrelevant and improper to consider for personal goodwill. Personal goodwill is a non-marital asset that's considered before you even get to an equitable distribution scheme. So you would take out personal goodwill, determine the value of the company, absent that, and then you consider equitable distribution. So she applied the wrong legal standard. In addition to that, the evidence doesn't support the fact that the entire business of the small insurance agency would remain intact if the husband left without a non-compete, which is essentially what that 7.3% means. So that's to say that if the husband walked across the street, opened an insurance company without a non-compete, virtually none of his clients would follow him. And that's directly contrary to the evidence in this case. The expert's testimony also was flawed because he didn't constitute competent evidence because he didn't rely on recent actual sales of similarly situated insurance agencies in a similar market. And that's what the law requires. He looked at insurance agencies that were sold in different states. We're not even sure which ones. And some of those transactions occurred nearly 20 years ago. So those were not recent sales in similarly situated markets. Also, he had no information about the type of insurance company it was, how it was run, and whether
isn't this valuation? It's similar to or equates to an appraisal, which is not an exact science, but you factor in all of the categories to come up with a reasonable fair market value. And didn't the judge do that here?
She did not do that here. You're right that a personal goodwill, when you're considering personal goodwill, you look at what that individual person brings to the business. The court didn't do that because she relied on expert testimony that was completely contradicted by the evidence. We didn't have any, if you look at the cases we cited in our brief, this is exactly what they say. It has to be similarly situated. It has to be the type of insurance agency, same kind of insurance agency involved. We have none of that information on any of that.
On the issue of the goodwill, based on the facts here, your client bought the business from his parents in 2014, I believe, for $1.5 million. It says that he had just come with the company for 5 years. So he at that time thought the company was worth $1.5 million for him to pay for it. And considering his father's goodwill, I mean, how do you pose the argument that your client's goodwill is now grossly inflated over what he considered his father's to be?
Well, he purchased the business, and you look at what he did over the 7 years that he's built this business, and he's done it through his relationships with clients. Even the wife agreed to this in her testimony. He did this with his strong relationships with his clients and his decisions and business acumen in growing the business. So what the error in the trial court's ruling and adopting the wife's expert's testimony is that it's incompetent because it doesn't follow Florida standard of similarly situated recent sales. And also it relies on arbitrary non-compete values arbitrary non-compete values that we have no idea what those insurance agencies were like. Those values are inputted by a broker, and who doesn't have anything to do with the company, and they're guesstimates. So evidence doesn't support the trial court's ruling. The expert's testimony was incompetent, and the data he relied on was unreliable. And my time is getting short, so just to go to the last primary issue of the ability to pay alimony, the husband, it's without dispute that the husband's gross income on his financial affidavit included pass-through income that included dollars he never sees. And the evidence was also undisputed that that money was used to pay the Westfield Bank loans. And that's totally proper. Under the Zold case and the Bear case that we cite in our briefs, it's proper for him to use pass-through income to pay corporate liabilities. And that's what he did. There's no evidence disputing that. The Supreme Court held that that pass-through, undistributed pass-through income cannot be considered in determining ability to pay. So when you don't consider the payments that he makes for the Westfield Bank loans, because that's money that is never in his pocket, you've inflated the amount that he's able to pay in alimony each month. And that needs to be taken into consideration, and the trial court erred in failing to consider that. She said it was a court, I'm sorry?
Is that true for both the principal and interest on the Westfield loans?
It's for the principal. Not the interest is expensed through the company. So the principal payments, which is the majority of the payments, I think the principal, the record's not entirely clear. I think the interest is about $400 a month on both loans together. And so it would be about $7,300 a month that was not considered and should be considered. So if you look at the chart that that the wife used in the answer brief, you have to deduct another $7,300 to get to what he's really left over with. So it was a grossly inflated value by not considering pass-through income. And the cases on pass-through income are very, very clear that you don't consider money that's not actually paid to him. And there was no contradictory evidence that the evidence was not, that the money was not paid to him. He just doesn't have it. Our last two arguments dealt with the wife's testimony on her actual need for alimony, what her actual need was. She reduced that at trial. She said it was overstated. So we assert that that's contrary to the evidence, and it should have been reduced by the amount she actually said, which would have been the $12,500 minus the imputed income of $3,000 a month. And then that the court didn't make sufficient findings on the life insurance because she repeated the legal conclusions that come out of the case law, but she never actually made findings on that. For example, if the husband passed away when he owed $500,000 to the wife, would she still get the whole $1.5 million policy limits, or would she only get the $500,000 that is actually owed to her? That wasn't put in there, and those are findings that need to be required. So I'll reserve the remainder of my time.
Thank you, counsel. I'll now call on counsel for the appellee.
Yes, Your Honor. May it please the court. Scott Walker on behalf of Kelsey King. I'm going to start with Ms. Davis's last argument that she made with respect to pass-through income. Of course, the controlling case in that regard is Zold versus Zold. As she stated, it's Supreme Court of Florida case. There's really a three-part test that the court should look to, starting with how much is the shareholder's interest in the subchapter S or corporation. In this case, of course, the testimony of the evidence was that the court, to the court that Mr. King owns 100% interest in KIA, King Insurance Agency. And in that sort of situation, the Supreme Court states that if you have a controlling interest in the corporation and you're speaking to retain earnings and income, the court should be very skeptical and very careful about what is going on there, because the income that the husband is pulling out of the business can be manipulated. So the three-part test is, what is the interest the husband has with respect to the business? Secondarily, is the corporation under Chapter 607 meeting its obligations and liabilities? And the third item is the retained earnings. Are they there for a set purpose? Now, Ms. Davis said that there was approximately $400 that was allocated to the interest income. Clearly, all of the witnesses on this point testify that this is a corporate obligation. The husband testified it was a corporate obligation. He said specifically that he's entitled to deduct the interest on on that obligation as well. And the corporation takes that deduction. He has the burden under Zold to specify what is specifically going on with respect to that particular pass-through income. He woefully did not meet that burden. Nowhere in the record is there any interest statement. So the payments are roughly $3,500 and $3,500 for Westfield 1 and 2, which is the principal item that we're talking about right now. And nowhere in the record does he say these loans were 5 years in existence. And nowhere does he say that the interest portion is 70% of that payment, 80%, 50%, or a 10% payment. It's just simply, it does not meet that burden in that regard. So that was point number one.
Counsel, it can't be that the interest is 100% of that payment. So even if it's 1%, and that's there's a legal definition of that S corp, income and what should be deducted. Isn't that error?
I would submit it is not, Your Honor, and because our trial judge had before her Trugman's report and the normalization process that he testified to. If the court will look at and refer to the balance sheet adjustments that Mr. Trugman provided, the court had on, it's found at record site 961, page 961, the court's own notes in reviewing the testimony was that the Westfield bank loans are amortized over time, and it relates to the book of business, and that's in the court's handwriting. So she was looking at not only interest payments, but the principal payments are also deducted and amortized, because all the witnesses testified that Westfield was used to buy the books of business. The books of business then are amortized on the King Insurance Agency tax returns. And in our brief, we cited each one of the tax returns, the schedules to the tax returns, and the court will note that in each instance, those books of business are amortized as well. So not only are we deducting the interest payments, but we're also, in 2017, it was $54,750 that was deducted off of the books as to the principal payments for Westfield. So not only are we deducting principal, but we're also deducting interest. And the court knew that, found that, and that was Mr. King's burden to establish exactly what was going on there with Westfield. Now, he was under cross-examination, and I asked him specifically the question, what amount is the interest? He said, on my financial affidavit, dollar for dollar, I'm deducting it against my income. That was his burden to clarify that, and he woefully missed on that burden. Now, the second point that I would go to, Your Honor, is that he has the ability to pay. He's earning $70,000 a year from King Insurance. The increase in income from 2013 to 2018, when the date of valuation occurred in September 24th of 2018, he had increased, over tripled his income from $200,000 in 2013 to over $700,000. His net month, or his income, gross income, was $58,000 per month. He did have a set off for payment to his mother. He has, of course, set off for his taxes and related expenses, but essentially he has at the end of all of that over $30,000 in which to pay for the expenses for the wife. And in this instance, the wife met her analysis for needs. She testified line by line, and she said that my needs are $15,000 a month. That comported with her financial affidavit. So there was a step-by-step analysis. She did say in the testimony that she had $120,000 allocated to her. She did not receive any support, no child support, no temporary alimony during the pendency, the 8 months of the pendency of this proceeding. She had that $120,000 with which to get her through the trial. And she was spending $15,000 a month. She was trying to trim off of that leading up to the trial to preserve as much money, because she knew that there was not going to be an allocation of temporary support or child support leading into the trial. So she trimmed some of the expenses up, but that was not in keeping with her overall needs. It was not in keeping with what her standard of living was. In fact, the husband's testimony at trial was running the house-related expenses, the maintenance, the pool man, the yard, all of the expenses, the standard of living for this party, just running the house alone, under the husband's own testimony, was $8,000 a month. And of course, the court determined that that was appropriate for the wife and the children in order to get receive the house in the equitable distribution. Now, if I might turn to the valuation issue that's brought up by the appellant, nothing could be further from the truth than what happened in this trial. The court used a galaxy of evidence that was received before the court. And namely, I'll start with the husband's own testimony. He was cross-examined at trial, and it was noted that he filed his financial affidavit in November of 2018. He put on his financial affidavit that he and the wife had had conversations with respect to valuation, and that the 1.5 multiple of gross revenues was what the valuation of the King Insurance Agency should involve. Furthermore, he testified under direct examination by his lawyer at trial. There was a question and answer series that went like this. Now, on this equitable distribution worksheet, we don't have a balance owed to Westfield, because you agree, don't you, that that amount has been taken into consideration in determining the valuation of King Insurance. His answer was yes. In other words, what he rolled Westfield into his value. And if you take the gross income that was occurring in September of 2018, which was roughly $2 million a year in 2017, about a like amount occurred, a little over $2 million in 2018 times 1.5. He did that math while he was on the witness stand. It yields a $3 million value. The court, in the judgment, and looking at page 12 of 43, in the final judgment, the court said there are a number of points of value in this case. The husband and the wife are very adept at valuing companies. They bought 7 books of business during the course of the 5 years that increased the value of this company, earning approximately $1 million a year when they took it over from mom and dad, to now $2 million a year at the time of the dissolution of marriage. And the court said, when we look at Mr. Trugman's initial determination value of $3.2 million using a 1.59 multiple, again, very similar to what the parties are using as a multiplier in order to achieve a market analysis, then we find that the parties were actively involved and very astute at handling these transactions, informing the basis of KIA evaluation of $3 million. So the court says that the husband's own valuation was $3.3 million. Mr. Trugman says 3.2 on his market valuation, and we know under Earp versus Earp and Soria that a business owner can value his own business, which he did here. Secondarily, we know that under Earp, the court is not constrained to the entirety of a valuation report. And I would submit to you that she took the portion of that report based upon not only the husband's own testimony, but the wife's testimony as well as the value, as well as there was that offer for Danny McKibben that was for $3.8 million, which accomplished the assumption of the Westfield debts as well. So there was a galaxy of information that was before the court, and where I believe the court discounted or Trugman lost on the credibility was his efforts to constantly devalue the equitable distribution that the wife would receive. In other words, his income analysis that he weighted inappropriately in this instance based upon Mr. Gray's testimony of revenue ruling 5960, and he combined the income approach along with the market assessment, and the income approach was less than the value that the parties had purchased King Insurance back in 2013, and then he weighted those to bring the value considerably lower. I would submit to you that Mr. Trugman then inappropriately takes the liabilities only, and then if you look at the balance sheet that is contained in his report, there's $964,000 of other assets. He does not appropriately take all of the assets and liabilities. He then takes the liabilities and tries to sever those liabilities out from the valuation, already discounting his overall value using the income approach, and then further discounting it by taking the liabilities. The balance, you have to take the assets and the liabilities, everything under Bear versus Bear. That's the proper analysis that the court must take in this process. And Mr. Trugman failed to do so, and he failed to maintain his credibility with the court based upon his testimony in completely diminishing or trying to value what the equitable distribution would be to the wife. Now, turning to the other point with respect to personal goodwill, I would say that Mr. Trugman further lost the court on that issue. Let's look at what he does. He takes the original purchase, $1.5 million in the book of business, the clientele of King Insurance Agency that the husband and wife purchased back in 2013. Along the way, they purchased these 7 other books of business and agencies using their business acumen to value those businesses and purchase them. All of those books of businesses are categorized under Mr. King, and he takes all of that and puts it under his umbrella, along with every employee that leaves. So we have 15 or 14 employees at the time that he takes the business over. Only 2 of those employees remain in 2018. And when that occurs, each employee that leaves that has sales, those employees are further categorized under Mr. King's book of business. So it artificially inflates, if you're using simply the commissions that Mr. King is allocated to. Again, remember, he has 100% interest in this business. He then has $1.1 million, and that is the methodology, which is not in keeping with Florida law, that Mr. Trugman uses to come up with a 68% number for personal goodwill, and that's artificial.
Well, let's talk about the expert testimony the trial judge did accept, which is the 7% goodwill evaluation by Mr. Gray. Given that testimony was based on this deal stat data that Mr. Gray testified himself was, it's arbitrary. There's no real valuation as to the individual business owners. It's checking a box. If that's the foundation of his personal goodwill valuation for this appellant, how can that be competent evidence?
Well, I would submit to you that Mr. Gray did not just rely upon the deal stat data. He took 33 deal stat cases and derived at his 7.3 number for personal goodwill, but he also had he attended the deposition for Mr. King. He had all of the information, the profit and loss statements. He had all of the tax statements. He had a great deal of information, not the least of which was the bookkeeping information that he had access to, which was Mrs. King herself. So he had a great deal more information than just simply looking at the deal stat data. In closing, we believe that the judgment of Suzanne Wilson Bullard in this instance should be affirmed in all respects.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I will try to go fast. Starting with personal goodwill, we've heard a lot about, just like in the answer brief, we've heard a lot of things that are completely irrelevant to the issues that are actually on appeal. And the issues on appeal can be decided by discrete legal issues that are established. First, personal goodwill. Gray's testimony was incompetent. The court applied the wrong legal standard. You don't consider whether it's inequitable or unreasonable for what the wife is getting when you determine personal goodwill. The record does not support the finding that no clients would go with him if he walked away without a non-compete. And Gray's evidence was simply incompetent and unreliable. On the Zold standard that Mr. Walker raised, the husband fully met his burden. The burden is showing how the money is used. It's undisputed that the pass-through income was used to pay these Westfield bank loans. It's not mismanaged. There's no evidence below or suggested here that it was mismanaged. That income is used to pay Westfield Bank loans and that pass-through income that is not dollars in his pocket cannot be considered in determining his ability to pay. The fact that it's amortized is a red herring. The way you look at the interest payments are expensed. So the interest payments are something that the corporation pays because they can be expensed and deducted. But amortizing has nothing to do with the fact that he makes these payments every single month, and that is made through the dollars that were included in the gross income on his financial affidavit. And so the law is clear that cannot be considered in determining ability to pay. On valuation, we can talk all day long about all of these different theories that the experts and the witnesses said or what the party said. Bottom line is, trial court adopted Trugman's theory. And that theory, she adopted half of it. And you can't, under established Florida law, you can't look at the assets and liabilities of a company and ignore a huge subset of it, which is exactly what was done here. There's no question about that. It's not like that debt just doesn't exist. And so if he were to sell the company, no one would care where that debt goes. It is a valid, legitimate debt, the Westfield Bank and the shareholder loans, that have to be deducted under established Florida law. And then the ability to pay issue, again, clear that that money goes to, is not money that goes to him, and that has to be deducted under the established case law. So the issues are discrete, they're simple, the evidence doesn't support the findings on personal goodwill. And I'm out of time, so I will stop talking. And we would ask that you reverse all of these counts.
Thank you both for your arguments. The court will be in a brief recess.